Live. Everywhere. On netrootsradio.com. David Waldman. Kagro. In the morning. Now, here's David Waldman.
Hey, good morning, everybody. How you doing? It is Friday, May 5th, 2023. Happy Cinco de Mayo, as I realized as I was putting together the Morning Post last night. Cinco de Mayo, of course, the most famous of holidays that Americans think Mexicans care about, but apparently they don't really actually care that much. But hey, it's there, and it's one of the few legitimate reasons, viewed by many to be one of the few legitimate reasons to buy Corona beers. And I don't really know why that's the case. There's plenty of other Mexican beers that are considerably better, but that and limes. The lime industry, I think, is behind the celebration of Cinco de Mayo, just the way the greeting card industry is behind so many other fantastic holidays. Does Hallmark do a Cinco de Mayo section? No, I don't even think so, because who would buy it? Just about nobody. All right. Well, we're up and about and ready to go, and there should be some additional background noise going on today. That'll be fun. And we were hard-pressed to get things ready and up and running on time. It doesn't sound that way, I'm sure, from the other side of the microphone. It just sounds like smooth transition every day. So here we go. We'll be coughing, clearing throat, making our way through Friday. I've discovered that my new morning radio breakfast diet of yogurt, bananas, and oatmeal. Probably a bad idea. I don't know. I should be doing a lot more gargling with salt water, I guess, in the morning instead. And it actually makes a big difference. But hey, and we haven't got the crutch of Greg Dworkin to come in and say, well, I'll let you talk while I figure out what's going on over here. Cough, cough. But doesn't matter. We have plenty to get to today. And I do have the crutch of Rosalind McGregor. So there's always that. That's helpful. And it lasts about oh, yes, that's right. Well, Greg will do 2 segments. And so it's about 5% of the length of Greg's segment. So, Rosalind, if you would please record 2 hours of commentary on what's happening in Michigan. And then I can break that up over the course of a couple of days. And I can take a nap, and the rest of you can enjoy what's going on there. All right. Well, anyway, that's not actually what we prefer to have happen. There is an update. I've just remembered it as I was getting ready for on air, and grabbed it and boosted the signal a little bit today, and didn't have as much time as I usually do to edit things up, i.e. 0 this time. But Rosalind's got it down by this point, so I'm not too worried about that. We'll roll that out. When we need a break from the rest of the themes we try to weave together from what's been hiding in pocket for a week, and some things we need to turn around and go back to. So, all right, where were we? Yesterday, we read the story of Clarence Thomas and Harlan Crow. Harlan Crow paying the tuition for Clarence Thomas's grandnephew, who he had semi-adopted and taken into the house. Mark Martin is his name, and sent him to some at least one. Sort of, I don't know whether is it fair to call it an elite boarding school? They were in a boarding school with an elite junior ROTC, Air Force junior ROTC program. We learned that much. Randolph-Macon Academy. And, by the way, I was sort of wondering this morning, thinking about that again and saying that no mention anywhere that Mark Martin, who's now in his 30s, had a career in the Air Force or anything. So I was just wondering whether that's particularly meaningful. What are the statistics in terms of kids who go to Randolph-Macon, who I guess they've got a big enough junior ROTC program that they are considered a military school? I wasn't sure whether that was really the case, but at least according to the Wikipedia profile, which is always correct about everything. They were considered, in the write-up anyway, to be a military academy of sorts. And how many kids who go to Randolph-Macon Academy, don't participate in the junior ROTC program? Is there a way to participate in the military aspect of the school and not be in Air Force? Is there a way to go to the school without participating in any military training whatsoever? I'm not really sure. And then I was just sort of wondering, if you go to a school that's known for having an elite junior Air Force, junior ROTC program, there's the bananas and yogurt for you. In case you're wondering, I did not have any bananas or yogurt. I take much more care about it than you would think. But anyway, can you participate in junior ROTC at the elite level and not expect to go on to, I assume, regular senior ROTC while you're away at college? And do you go on to a career with the Air Force? There have to be, of course, a tremendous number of kids who go to Randolph-Macon Academy and don't end up in the Air Force. But it does seem like kind of a waste of time. Well, anyway, who knows? I don't know what the program is like. I was just wondering about that and whether Mark Martin had gone on and made use of that or not. And maybe not, as he switched schools at some point and spent a year away at Hidden Lake, which was also interesting in its own right. Anyway, there's a little bit more, just a little bit more, about Clarence Thomas and Harlan Crow, a follow-up from ProPublica that doesn't add a great deal to it, but it does offer somebody's attempt at defending Thomas in all this. And it's not surprising. I mean, it's sort of surprising that people bother to defend him, but it's not surprising the composition of this defense, I guess, is what I should say. And let's take a look at it and give it to you word for word so that we can, give this person their due, which isn't much. But, all right, let's see. Oh, look, and I have some other additional direction here this morning from John Shiflett. Good morning, John. How you doing? Thanks for tooting to everybody. God, I'll never get that right. That we're live and on the air. And about to bring you this fabulous news from, of course, the same team, I think. Justin Elliott, Joshua Kaplan, Alex Mirjeski, and Brett Murphy. Was Brett Murphy on the last one? All right. Well, he's on this one, and that's what really counts. Okay. Dallas real estate billionaire Harlan Crow, we know him, paid tuition for Supreme Court Justice Clarence Thomas's grandnephew for 2 years at 2 private boarding schools, according to a statement released yesterday, by a longtime friend of Thomas's. That is to say, Clarence Thomas's, not a longtime friend of Thomas's English Muffins. That would be me. Anyway, the statement came in response to a ProPublica story that disclosed Crow had paid the fees at 2 schools for Mark Martin, not the NASCAR driver, but the grandnephew, a relative who Thomas had legal guardianship of. And again, this was legal guardianship. And Thomas is supposed to know a thing or two about what that means. Legal anything, really. You should be able to turn to a Supreme Court justice and pretty much get an explanation. Legal anything, I would think. But in this case, legal guardianship, profoundly misunderstood by both Clarence Thomas and his friends, as you'll see. So he had legal guardianship of this, of Mark Martin, and said he was raising him, quote, as a son, which he was a son to somebody, just not Clarence Thomas. Thomas did not include the payments in the financial disclosures. He is required by who? By, I don't know, people who, expect such things, because there's no enforcement of it, but required to file each year. Now, who's stepping into the role of defender? Poor sucker that he is. His name is Mark Paoletta. That's the friend. Acknowledged that Crow paid Martin's tuition. I'm not sure why they turned to him to ask this, but I'm sure it makes sense to the writers. They asked Mark Paoletta about this, and he acknowledged that Crow paid tuition both at Randolph-Macon Academy in Virginia and Hidden Lake Academy in Georgia, saying Crow paid for 1 year at each school. Paoletta did not give a total amount, But based on the tuition rates at the time, the 2 years would amount to roughly $100,000. Remember, yesterday's speculation was it could have been up to about $150,000 worth of tuition in total that he paid if he went to XYZ combination of these two schools for 4 years. Martin attended Randolph-Macon for multiple years, and the statement did not say who had paid for the remainder of his high school education. Paoletta, Crow, and Thomas did not respond to further requests for comment. The revelation of the tuition payments deepens the financial ties between Crow, a Republican megadonor, and Thomas, who earns $285,000 a year as a Supreme Court justice. So, a pittance. Last month, ProPublica reported that Crow had paid for decades of luxury vacations and travel for Thomas and his wife, and had bought the home of Thomas's mother, making tens of thousands of dollars of improvements to it. Was it Philip Bump yesterday writing, tooting I saw on Mastodon, just noting for the record that, by the way, springing for this tuition sounds expensive. And it is expensive, and it's expensive to, even if you are earning $285,000 a year as a Supreme Court justice, or $285,000, as anything, a bricklayer, if it happens, whatever, $285,000, you have to pay, $50,000 worth of tuition a year. It's a lot. It's expensive. Some people can afford it better. If you're making $285,000, it's easier, but it's still something. It's tough. But for a billionaire, so if you pay $50,000 or so tuition for a billionaire, well, by comparison, I think somebody worked it out and said if you were earning, and it was Philip Bump, I'm pretty sure, if you were earning $60,000 a year, a much more mainstream level income, $60,000 a year, if you paid the equivalent of what a billionaire, in other words, he did the math here. For a $60,000, oh, no, it wasn't the tuition, I think, or was it? Maybe that was just the basis of it. But they were saying why would you even bother? Like $50,000, and then you're claiming that I don't have any cases in front of the judge, and I'm not asking for anything, and there's no quid pro quo, and they didn't need any sort of immediate return. Who would lay out $50,000 that way? Who would buy mom's property? Who would take him on a luxury vacation? Who would lay out in the vacation column of the ledger $500,000, right? So why bother? Well, they were pointing out that it would be the rough equivalent for a person earning $60,000 of investing 36 cents in someone's education so that you might be able to curry some favor with the justice. It's not a whole lot of money that you're wagering. And what kind of return on investment are you getting for that $50,000? Who cares? For most people, it's like 36 cents for most people. If you could buy, he asked, a Supreme Court justice's undying loyalty for 36 cents a year or a month, whatever the basis was, wouldn't you try and do it? It's actually a pretty good point, and a good point probably made very often by people who are frequent commenters about just the impropriety of even being a billionaire. And there's no way to get yourself to billionaire status without something having gone pretty seriously wrong with the market system, or at least with the equity of the market. And when you have that many people running around with that much disposable income, the temptation to do bad things with it, even if you think you're doing a good thing, I'm sending a kid to school, right? The temptation to throw money around is just overwhelming. The idea, it means literally nothing to you money-wise. So what the hell? Let's do it. I thought that was an interesting perspective. But it wasn't in this article, which is what I was trying to read to you. So I'll get back to that. So, we were going to marvel together at the weird attempt and an excuse that Mark Paoletta cobbled together for Clarence Thomas. Ready? This story, that is yesterday's story about the payments, is another attempt to manufacture a scandal about Justice Thomas. It came pre-assembled. The whole scandal was in a box, gift wrapped. I don't know. Anyway, He goes on to say, but let's be clear about what is supposedly scandalous now. Justice Thomas and his wife devoted 12 years of their lives, that's life, as a plural, lives, to taking in and caring for a beloved child who was not their own, just as Justice Thomas's grandparents had done for him. Well, yes, they did take in the kid. They devoted 12 years of their lives, I assume, to taking in and caring for him. And I don't think they were neglectful in any way, even though they did send him to boarding school. That's actually considered a bonus in some circles. And maybe the kid liked it better than living with them anyway. But, okay, good. They took care of him. Now, the no part comes with, well, one, no, you can't hide income from another source and pretend it didn't come to you and you didn't benefit from it and there wasn't something wrong with hiding it from disclosure. But then, of course, the last part there, right, just as Justice Thomas's grandparents had done for him. Is that so? Were there billionaires paying Justice Thomas's grandparents to send him to Harvard, Yale, wherever? What about that? He went to one of the elite institutions. Who was paying the tuition? It may have been scholarships. It may have been a generous benefactor, even a billionaire, for all we know. But of course, Justice Thomas's grandparents weren't sitting on the Supreme Court and had no disclosure obligations. And so really, the whole just like his grandparents is, that's a red herring. You should have expected that from the beginning. He goes on, though, to say they made many personal and financial sacrifices to do this, and along the way, their friends joined them in doing everything possible to give this child a future. Well, okay. One of the problems, of course, is that they didn't actually make the financial sacrifice to do the tuition at Randolph-Macon Academy. Someone else did. That's the thing. They certain made other financial sacrifices as well, even though they were able to take Mark with them on these fabulous vacations. Apparently that was cleared up in the story yesterday too. So it's good to take kids in. It's even good to accept donations towards their education. It's just not good ever to have a financial disclosure obligation and blow it off. That's bad all by itself. And then to pretend that it's awesome to do so is just doubly bad. Paoletta asserted that Thomas was not required to report the tuition payments made directly to these schools. Basically, their view of this is, well, we financially engineered it such that the money never landed in Thomas's accounts, and so therefore we don't have to disclose it. Interesting legalistic reasoning, but actually improper and incorrect. The actual legal reasoning is explained in the next paragraph. But in the fake news paragraph from Mark Paoletta, he says Thomas didn't have to report the tuition payments because they were made directly to the schools, and he didn't have to report that because Martin was not his, quote, dependent child as defined by federal disclosure law. They took him in. They devoted years. They made financial sacrifices and personal sacrifices. They raised him as a son. But he's not a dependent child. Yeah. By the way, that smacks of Donald Trump's treatment of his taxation and income situation, right? How much is this property worth? Oh, it depends. Who's asking? Are you the tax guys? The property's worth $1. How much is this property worth? Oh, who's asking? Oh, you're the guys I'm trying to get a loan from and use this property as a collateral? Property's worth $1 billion. Okay, sure, right. I'm so deserving of plaudits. I took in this child. I sacrificed. I devoted myself to him. I raised him like a son. Taxman comes and says, hey, you received this gift of tuition for this kid that you took in and devoted your life to like a son. Is he your son? What? No, never heard of him. Don't know what you're talking about. Sure, I don't think so. Thomas has said he was advised that he didn't need to disclose the luxury travel because it was hospitality from a friend. That's on the travel side of the ledger. By the way, who advises Supreme Court justices about legalisms like that? I'm just a little bit curious. That was my accountant. They know the accounting rules. Well, it's a rules-based system. You could probably interpret it from yourself. You're one of the 9 greatest legal minds in the country. What's happening? How come you can't figure this out? Some people think you're one of the greatest of all time. That's apparently down at the bottom of this article today. All right, well, here's what actual legal ethics experts say. Granted, not one of the top 9 in the country, but experts nonetheless. They said the justice should have disclosed the payments as a gift because they defray tuition costs that he would otherwise have been responsible for paying because he's the blank guardian. What kind of guardian? Give you a hint. You already know the answer, but the word we're looking for in blank guardian is probably the worst, most incriminating one you can think of when you contemplate that it was apparently way over the head of a Supreme Court justice. That's right, of course, legal guardian. Thomas did disclose several years earlier a $5,000 gift to help with Martin's education from another friend. We heard about that one, but that guy ran a pest control company, and so it's fine to talk about his $5,000. What about this other guy, a major mega donor, real estate mogul, et cetera, could certainly have business before the court at any given time. Those gifts I won't disclose. Minor children, of course, we're reminded, are seldom responsible for their own tuition. Martin told ProPublica in an interview that he had not been aware that Crow had paid his fees. That wouldn't surprise me at all. In Washington, prominent Democratic lawmakers renewed calls for ethics reform. One called for a Justice Department investigation. Okay, fine, pretty much standard. Dick Durbin chimes in here. I'm actually going to give short shrift to the Democrats in this because you know what they're saying. We should totally look into this. All right, so we should. Who else thinks so? Ron Wyden thinks so, and Richard Blumenthal thinks so, and they're all mad that Justice Roberts won't show up to testify. Sheldon Whitehouse thinks so. He's been trying to pass a bill to establish ethics rules for the justices for a long time. It's gone nowhere. At a Senate Judiciary Committee hearing on Tuesday, an array of experts, including a retired federal judge and a former attorney general in the administration of President George W. Bush, debated the constitutionality of Congress regulating the Supreme Court, as well as the balancing act between 2 pillars of American government, checks and balances versus the separation of powers. Former Federal Circuit Judge J. Michael Luttig, you remember him, or I should say, you remember J. Michael Luttig, a conservative and noted slow talker who sent a letter to the committee ahead of Tuesday's hearing and argued that Supreme Court justices need to act and appear, quote, beyond reproach. Yes, it's the appearance of impropriety you're seeking to avoid here. He said Congress can pass laws to codify ethical standards for Supreme Court justices, but Luttig added lawmakers shouldn't have to. The judicial power, the power of the Supreme Court, is ultimately dependent on the respect that its judgments command, or not, from the American people, he wrote. Whether the Supreme Court is subject to ethical standards of conduct is not emphatically not a partisan political issue and must not become one. During the hearing, Democrats led by Durbin and Whitehouse said there is a long tradition of Congress passing laws to regulate the Supreme Court's administration, which they said is decidedly separate from the justice's decision-making remit. That's a good point. Republicans said lawmakers across the aisle only care about enforcing ethics rules because they dislike the majority conservative Supreme Court. No, but that's what we expected you to say. But it's a good point here, by the way, to say, well, you can't enforce these rules as against the Supreme Court because they're a separate branch and separate, separation of powers, et cetera, et cetera. Yeah, that's a starting point. But then remember what the separation of powers is all about and which powers we're talking about. It would be improper for Congress to interfere in the legal decision-making processes of the Supreme Court, but not, it's argued here, necessarily improper for them to make certain requirements about how the courts are administered. There is, of course, the administrative offices of the courts, and that's was an office established by statute by Congress, and there are certain accounting rules and certain hiring practices for clerks and for marshals and other employees of the court, and there are certain ways in which the court function. For instance, the Judiciary Act, or the entire establishment of the hierarchy of the federal judiciary. How many district courts will there be? How many districts in each state? How many circuit courts of appeals, the size of those courts of appeals, and how many judges will sit on them, and of course, how many justices will sit on the Supreme Court, all established as a matter of law, and nobody has any problem with that. Everybody knows that Congress could, if they wanted to, alter the size of the Supreme Court, even without a constitutional amendment, because there's nothing about the size of the court in the Constitution. But you can't say, well, they're not allowed to establish courts or anything like that, or, determine what the size of the panels will be, because it's a separate branch. They determine that stuff all the time. It's an excellent point that's actually been lost in a lot of this debate, and probably I think we've overlooked it. I've overlooked it as well, in insinuating that there's just nothing you can do about this stuff. I guess when it comes to actually enforcement is where it becomes a problem. Anyway, Lindsey Graham, to no one's surprise, poo-poos the whole thing and says this is selective outrage. And, Democrats have spent the last couple of days saying, no, we would insist on this sort of ethical investigation, even if it was a Democrat doing this stuff. And yet none of them are doing it. And so it makes it very difficult to prove as much. Hi, everybody. It's me, David Waldman. Yes, the same guy who interrupts you all the time. Interrupting you one more time just to tell you again, another reminder that your contributions are what keep this show on the air, and patreon.com, patreon.com, is still among the easiest ways to make the sustaining subscription donations that keep us afloat. Are you ready for the pep talk about how our Patreon campaign is still going strong and growing? Well, too bad. Yeah, the plain fact is we actually are headed in the wrong direction, and whereas we once had about 175 monthly patrons, we're now actually down below 150. Time to recruit some more. Not exactly the kind of news I wanted to share, but there it is. For those of you in a position to support the show, patreon.com does make it easy to make those secure, recurring monthly contributions to do so. Patreon.com/KagroX gets you straight to our donation page. We've been through a lot together. The worst of the pandemic, we hope. The worst of the insurrection, we hope. So go ahead and treat yourself. You don't need an excuse. Give yourself the gift of a little something you enjoy in life. Support the show. And of course, if you happen to prefer using PayPal or even the Square Cash app, we're up and running on those options too. So thanks again, everyone, for all your support. We couldn't, or at least shouldn't, do it without you. Hope you'll be on board soon too. Thanks for all your support. All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. While we were away, this happened. Actually, I discovered that this happened while we were away. The World Health Organization, who exactly, declared an end to the COVID-19 pandemic's emergency status, a milestone, it is said here, as the virus becomes a routine illness, which is not a great thing necessarily, but certainly people have been out there behaving as though it were over for quite some time. So no surprise there. Where's the article from? Oh, the Wall Street Journal is reporting this. We won't be able to read it because, of course, everything is paywalled, but I can at least refer you to some official source that says that this is true, and they were probably dependent on some other source, and you might be able to find that one even with the paywall in your way if you want to get back to the original source. But I just by way of showing you something, the Wall Street Journal was the one reporting it. It came to me via all sorts of convoluted internet tubes and then through Mastodon at the end. But okay, so we got that on the record. Oh, yes, right. I was going to say that right at the bottom of this article, I had made some reference to someone who thought that Thomas is one of the great justices of all time. Let's see, after Lindsey Graham threw out his ridiculous response and saying that this was selective outrage, Mitt Romney chimed in saying, by the way, if the reports are accurate, it stinks, he told reporters. Well, that's good. We should write that down. It stinks, and we'll see what kind of power that has. Thursday morning, though, the Twitter account for the Republicans on the House Judiciary Committee, who really have nothing to do with anything, they could do oversight if they wanted to, but they don't, invited followers to retweet a tweet featuring a goat emoji. Goat, G-O-A-T, of course. Shorthand for the greatest of all time, G-O-A-T. It's also shorthand for the greediest of all time, so I guess you could, in fact, retweet RT if you think Justice Thomas is the goat emoji. I think he's an actual goat, and but if you wanted to talk acronyms, GOAT still works, even if you think he's in the wrong. All right, let's see. Other things to catch up on. There are many. Yesterday we spent a good deal of time on court affairs, legal affairs, and I guess we'll be doing the same again today, because that just, what can I tell you? That's going to dominate the news. There's more about Thomas. Do I do more about Thomas first? Or go, yeah, sure, why not? I'll keep with the theme. More Thomas news it is this morning, isn't it? All right, or yesterday, May the 4th. Yes, okay, Star Wars Day, which, by the way, because it's 5/4, I'm also reliably informed. We discussed this one year that is Dave Brubeck Day, and okay, that's the time signature most famous among those in his work. But yes, from yesterday's Washington Post, judicial activist directed fees to Clarence Thomas's wife and urged no mention of Ginni. And now I'm thinking, oh my gosh, this is going to eat up the rest of the show, because it now reminds me there's something else I need to return to. But this involves Leonard Leo, and will serve as a good reminder of exactly who he is. He's been a big part of all the stories lately, and I was just trying to connect to our previous discussions, but it's been a couple of years since we talked about Leonard Leo. But I did get a nice note from listener, was it Jeremy Freiberg who sent me this? Yeah, and who said, the discussion of Leonard Leo, it was a couple of years ago, but it was like really extensive. And he was just saying, it was good preparation. And if you were a long-time listener and you had the benefit of having heard those shows and those discussions of Leonard Leo, it says here 3 to 4 years ago now, then you were well prepared when his name came up and you didn't need any further reference. But some of you may have come in the middle of the whole run of, 12 years of the show here, and need a refresher. And I'm not certain how comprehensive a refresher this will be, but the judicial activist that directed fees to Clarence Thomas's wife, that's Leonard Leo. Guy behind the Federalist Society that you've heard a lot about, that's Leonard Leo. Guy who got roped in a $1.6 billion contribution to the Federalist Society and to their programs and to reshape the federal judiciary, that's Leonard Leo. Major mega donor behind the George Mason University Law School scheme of holding classes overseas and getting Supreme Court justices to teach them as junkets. That's Leonard Leo. Guy who engineered the major donation to the school that saw them rename it for Antonin Scalia. That's Leonard Leo. So that's what we're talking about here. Who is Leonard Leo? I don't know. He's this guy. Leonard Leo, in this story, told GOP pollster Kellyanne Conway, another, major mover in evil circles, to bill his nonprofit and then to use the money to pay the spouse of Supreme Court Justice Clarence Thomas. But this is all done in headline shorthand. Emma Brown, Sean Boberg, and Jonathan O'Connell wrote this piece, and it goes like this. Conservative judicial activist Leonard Leo arranged for the wife of Supreme Court Justice, all his relatives are getting paid in this, the wife of Supreme Court Justice Clarence Thomas, to be paid tens of thousands of dollars for consulting work just over a decade ago, specifying that her name be left off billing paperwork because they're so open and honest about what they're doing, according to documents reviewed by the Washington Post. In January of 2012, it's 10 years ago now, more, Leo instructed the GOP pollster, Kellyanne Conway, to bill a nonprofit group he advises and use that money to pay Virginia Ginni Thomas, the documents show. The same year, the nonprofit, the Judicial Education Project, filed a brief to the Supreme Court in a landmark voting rights case. And why would Clarence Thomas be interested in that? Leo, a key figure in a network of nonprofits that has worked to support the nominations of conservative judges, told Conway that he wanted her to give, quote, give Ginni Thomas, quote, another $25K, the documents show. He emphasized that the paperwork should have, quote, no mention of Ginni, of course, unquote. And, all you need to do to work your way up in this world is study, work hard, play by the rules, and if you need $25,000, call a billionaire and ask for it. Conway's firm, the polling company, brilliant name, sent the Judicial Education Project a $25,000 bill that day. Per Leo's instructions, it listed the purpose as, quote, supplement for Constitution polling and opinion consulting, the documents show. How do you feel about the Constitution? Good. $25,000, please. In all, according to the documents, the polling company paid Thomas's firm, Liberty Consulting, $80,000 between June of 2011 and June of 2012, and it expected to pay $20,000 more before the end of 2012. What do you know? Around $100,000. The documents reviewed by the Post do not indicate the precise nature of any work Thomas did for the Judicial Education Project or the polling company, except that there was $100,000 attached to it. The arrangement reveals that Leo, a longtime Federalist Society leader and friend of the Thomases, has functioned not only as an ideological ally of Clarence Thomas's, but also has worked to provide financial remuneration to his family. And it shows Leo arranging for the money to be drawn from a nonprofit that soon would have an interest before the court. Sounds actually kind of for-profit, doesn't it? In response to questions from the Post, Leo issued a statement defending the Thomases. Quote, it's no secret that Ginni Thomas has a long history of working on issues within the conservative movement, and part of that work has involved gauging public attitudes and sentiment. The work she did here did not involve anything connected with either the court's business or with other legal issues, he wrote. As an advisor to JEP, Judicial Education Project, I have long been supportive of its opinion research related to limited government. And the polling company, along with Ginni Thomas's help, has been invaluable as a resource for gauging public attitudes. Wow. Of the effort to keep Thomas's name off the paperwork, Leo said, knowing how disrespectful, malicious, and gossipy people can be, I have always tried to protect the privacy of Justice Thomas and Ginni. Yeah, but it's illegal. Oh, well, says you. I own a justice, though, so maybe it isn't. Leo's statement did not address questions about whether he had arranged other work for Ginni Thomas or how much money he directed to her in all from the nonprofit. Conway, who was a senior advisor in the Trump White House, did not respond to messages seeking comment. The Thomases did not respond to messages seeking comment. Ginni Thomas, a political activist and former GOP aide on Capitol Hill, has long maintained that she and her husband keep their careers separate. In December of 2012, the Judicial Education Project submitted an amicus brief in Shelby County versus Holder, a case challenging a landmark civil rights law aimed at protecting minority voters. The court struck down a formula in the Voting Rights Act that determined which states had to obtain federal clearance before changing their voting rules and procedures. Thomas was part of the 5-4 majority. Thomas issued a concurring opinion in the case, arguing that the pre-clearance requirement itself is unconstitutional. Nobody else helped out in that one, I don't think, but Thomas's opinion, which was consistent with the previous opinion he wrote, favored the outcome of the Judicial Education Project, and several other conservative organizations had advocated in their amicus briefs. He did not cite the JEP brief, however. Legal ethics experts disagreed about whether the arrangement outlined by Leo and the payments from Conway should have led Thomas to recuse himself from the Shelby case. Federal law requires justices to recuse if their impartiality might reasonably be questioned. a standard that has not been well defined as applied to filers of amicus briefs, the experts said. Law professor Kathleen Clark of Washington University said that if the Judicial Education Project paid Ginni Thomas $100,000 in a year and a half before it filed its brief, the size and timing of the payments would have been enough to cast doubt on Clarence Thomas's impartiality and require his recusal. Law professor Stephen Gillers of New York University, however, said that as the rule is now interpreted, the link appeared too attenuated to require recusal. But both experts said the arrangement shows that current ethics rules and disclosure requirements fail to protect the public confidence in the independence of the courts. For example, although justices must report the name of companies that pay their spouses, they are not required to report the names of the company's clients. In this case, even if there were such a requirement, it's not clear that the Judicial Education Project would have been listed as a client because the fees intended for Ginni Thomas were to go through Conway, another financial engineering arrangement, so that they can convince themselves that it's okay for them to hide the information. The idea that Leonard Leo, who has a passionate ideological interest in how the court rules and who has worked hard for years to advance that interest, could pick up the phone and generate substantial compensation to Virginia Thomas, which also benefits Clarence Thomas, that idea is bad for the country, the court, and the rule of law, Gillers said. It's not the way the Supreme Court should do business or allow its business to be done. The effort to keep Ginni Thomas's name off the paperwork makes the arrangement seem even more egregious, said Clark. In his statement to the Post, Leo said that Ginni Thomas's work had no bearing on her husband's opinions. I have known Clarence and Ginni Thomas since 1990. So what? They are dear friends, another set, and are people of tremendous goodwill and integrity. Anybody who thinks that Justice Thomas is influenced in his work by what others say or do, including his wife, Ginni, is completely ignorant of who this man is and what he stands for. And anybody who thinks Ginni Thomas would seek to influence the Supreme Court's work, oh my goodness, no, is completely ignorant of the respect she has for her husband and the important role that he and his colleagues play in our society. Leo, 57, has for years been the behind-the-scenes leader of a network of interlocking nonprofits that has raised and spent hundreds of millions of dollars, billions in fact, to support conservative judges and causes. Marble Freedom Trust, one of the organizations Leo chairs, received a contribution worth $1.6 billion, there's that number again, in 2020 from a Chicago businessman. And for those of you who've been listening to the show in the past week, the bells will ring if you also have a good memory. Chicago businessman Barry Seed. And I guess I still don't know how he actually pronounces his name. Barry, B-A-R-R-E, which I'm pronouncing as O or a Y. And Seed, S-E-I-D. Anyway, his name came up the other day when we were reading the story about the George Mason University Law School things. It was largely his funding that made a lot of those things happen as well. And then we jumped out of that story because we ran out of time at the end of the day, just as his name was coming up. The Judicial Education Project was part of that network, although Leo was not listed on its tax filings for some strange reason, or in corporation records. Leo's allies founded the Judicial Education Project in 2004. Its mission was to, quote, conduct research and educate the public on the role of the judiciary as laid out in the U.S. Constitution. Well, Schoolhouse Rock did that. According to its tax filings, it secured tax-exempt status in 2011 and was not initially well-funded, filing paperwork with the IRS indicating it brought in less than $50,000 annually. In 2012, it received about $1.5 million from donors whose identities were not publicly disclosed, the tax filings show. The Judicial Education Project spent $150,000 on, quote, polling that year, 10% of its total income. According to its tax filing, the filing does not identify which firm did the work. The president of the Judicial Education Project that year was Neil Corkery, a Leo ally and bookkeeper for several of his nonprofit groups. Corkery certified the group's 2012 tax filings that no one other than the group's officers or key employees had control over the nonprofit. I wonder what was going on in 2012. I can't really put my finger on it, but a lot of these judicial act, there was something like Judicial Emergency Network and something like a Judicial Confirmation Network also was all founded around the time that the nuclear option first came up with respect to the filibusters of several federal judges and the back and forth between, this would be the 2004-2005 threat by the then Republican majority in the Senate to use the nuclear option to blow up the filibuster for federal judicial nominations because Democrats were blocking a number of nominations. And at that point, a lot of these conservative foundations started judicial activism networks, and they all were, polling on, shouldn't we basically bury all Democrats alive in order to get these judges through because it's such a horrific thing that they're doing, which we're going to do in a couple of years. Let's do some polling on it. All right. Well, the president of the Judicial Education Project that year, right, I said, 2012, Neil Corkery. Corkery, of course, declined to comment for this story. Clarence Thomas has been under scrutiny since ProPublica revealed in April that Texas billionaire Harlan Crow took him on lavish vacations and also bought from Thomas and his relatives a Georgia home where Thomas's mother lived. The transaction was not listed on the justice's disclosure forms. Senate Democrats this week held hearings to gripe about this. Couldn't get Chief Justice Roberts to show up for it. During the hearing, Sheldon Whitehouse mentioned Leo, who the Post has reported used the nonprofit network during the Trump administration to conduct publicity campaigns in support of nominees he helped select. This guy doesn't have business before the court, Whitehouse said. His business is the court. Interesting way of putting it. Leo's ties to the Thomases go back decades and span their personal and professional lives. Leo advised Clarence Thomas through his contentious confirmation process in the early 1990s and made Thomas the godfather of one of his children. It's a good way to pretend that you have a close enough relationship that you can do almost anything and pay for almost anything. Leo also has hosted the justice at his New England vacation home. And this guy gets around to vacation homes. According to the New York Times, at a Federalist Society event in 2018, Thomas shared a stage with Leo and jokingly told him, "You're the number 3 most powerful person in the world." That is a funny joke. That's a good one. He must have killed with that. The year before that, Ginni Thomas called Leo, quote, "a mentor to me and a hero," when she honored him with one of her Impact Awards for conservative activists. Oh, the awards circuit. That's very Trumpian. Leonard Leo has single-handedly changed the face of the judiciary, she said at the awards dinner held at what was then the Trump International Hotel in Washington. He has many hats, and they're just not talking about actual hats necessarily, but maybe he has many of those as well. That isn't even all he does. He does not really tell all that he does. Oh my, that's true enough. But I know enough to know the man is a force of nature. In 2009, when Thomas founded a Tea Party-aligned nonprofit called Liberty Central, Leo served on the board. Tax filing show. Corkery was the nonprofit's accountant. Public records show. Thomas stepped away from Liberty Central in late 2010 amid, controversy. Wow. Over whether its anonymous funding, including one donation of $500,000, posed a potential conflict of interest for her husband. Politico reported the following year that the donation had come from Harlan Crow. Another $500,000 from Harlan Crow. Can't believe it. Wow. So crazy. She then formed Liberty Consulting, which was basically the same thing. A for-profit firm, though. On her LinkedIn page, Thomas describes her work as collaborating with, quote, citizen activists, Leonard Leo, leaders and nonprofits to succeed and have an impact in defending the principles that have made America an exceptional nation. That's meaningless word salad. Liberty Consulting began receiving payments from Conway's firm within months of its creation in 2011. On multiple occasions, Thomas contacted the polling company to discuss her payments. The documents show, "You're late for paying me for my no-show job." The documents did not indicate whether Thomas knew of Leo's role in the arrangement with Conway's company or of the Judicial Education Project's role. Conway sold the company in 2017 to what is now known as CRC Advisors, another firm that Leo chairs. What do you know? Since its first amicus brief in the voting rights case in 2012, the Judicial Education Project has submitted about a dozen amicus briefs to the Supreme Court. That's not a whole lot. It has argued for limiting or rolling back race-based college admission policies, regulations on greenhouse gas emissions, and gun control measures. In 2014, the group filed a brief in the Hobby Lobby case which challenged a mandate in the Affordable Care Act that employers make contraception available to workers at no cost to the workers. The court's ruling struck down part of the requirement in a split decision with Clarence Thomas, again in a narrow majority. Thomas's votes were aligned with the Judicial Education Project, of course, in 6 of the cases in which it filed briefs. Only 6 out of the 12? Including the Hobby Lobby case, and 2 involving affirmative action at public universities. Thomas, a longtime critic of affirmative action, voted with the majority to uphold Michigan's prohibition, on race-based admissions at its public universities, and he dissented in a ruling that upheld admissions policies at the University of Texas. Thomas's votes did not align with the group's position in 3 other cases, including one that largely upheld the Environmental Protection Agency's ability to regulate greenhouse gas emissions. The court did not take up all the cases in which the Judicial Education Project filed briefs. The group's interest in the Supreme Court extended beyond the courtroom. It spent money on campaigns to support President Donald Trump's nominations of Brett Kavanaugh and Neil Gorsuch. It listed as a funder in the credits of a 2020 documentary that celebrated Thomas. Oh, it is listed. Okay. And Clarence and Ginni Thomas are featured extensively in this documentary titled Created Equal, Justice Thomas, in his own words, talking about the justice's upbringing and his judicial philosophy. As the Judicial Education Project pushed for a conservative court, the group grew into a financial juggernaut and was rebranded as the 85 Fund. Between 2020 and 2021, its revenue nearly doubled from about $66 million to more than $117 million, tax forms show. Even so, the group has never had more than a handful of employees, tax filings show. It has listed its main office address as a UPS store situated amid row houses and retail stores in the Georgetown neighborhood of D.C. because it's totally legitimate. Wow. What a show. Okay. There's more, of course, and, let's see. Where's the, I got something yesterday. Did I not, park it in Pocket or what? But, let's see. Let me look it up now because I'm reminded that my brother Mark sent me something yesterday that had something to do with this storyline, and I'm going to have to find it again. Oh, yes. Okay. And labeled with the comment, breaking the law is not an impeachable offense anymore. And how wonderful that is. He was in fact pointing to the story we read yesterday about the tuition payments. Okay. So, all right, we're on track. It wasn't an additional piece of this story that would otherwise be missing. Okay. Gosh, that's a lot. Let's see. Other things worth bringing up that I can still cram in. Maybe we can get to the end of this. Yesterday we read the first half of, and maybe you went on to read the rest of it, the story that Scott had provided us yesterday about the brazen attacks on Ohioans' voting rights, the 111-year-old tradition of voting rights that makes it possible and reasonable for Ohioans to get ballot legislative matters onto the ballot initiatives, and 2, to amend their constitution by a referendum vote, and that there were some tricky changes going on. And just to refresh your memory, we'll skim through the top part of it, but then get down to where we left off yesterday. This was an editorial in the Plain Dealer, which labeled this way: in one of the most shameless power grabs in Ohio history, State House Republicans, including evidently Governor Mike DeWine, are aiming to make it harder for Ohio voters to amend the state's constitution. And not only were they changing the qualification rules for getting a measure on the ballot, but they were making these changes, and recommending that these changes be ratified by a citizen referendum in a very traditionally very low turnout setting, an August special election. This because they figured that with turnout so low, if they turned out their activist base, they could get the amendment passed the way they wanted to. But this despite the fact that the same Republicans had just banned constitutional amendment referenda during August elections because they're so low turnout. But what they were afraid of was that they could motivate, that the other side would be able to take advantage of motivating its base in a low turnout election and amend the Constitution. So they prohibited that from happening ever again. And you would think, well, they're also, eliminating the possibility that they too could motivate their base and make a constitutional amendment that way. So, at least it's even-handed and nobody's going to be able to do it. But how amazing. They actually said, well, we'll have one more exception for us. And then after that, no one is allowed to use these low turnout elections for constitutional amendments after we do it one more time. So essentially what they said was, in Ohio, Republicans are allowed to amend the Constitution this easy and underhanded way, but Democrats are not. That's just fair. So we're doing it. That's the most amazing part of all of this. All right. So I also left off after noting that Democratic and Republican former governors have condemned this crazy little maneuver, especially the part about the fact that just 21 days ago, the election or the new rule prohibiting the use of these special elections in August for this stuff had just passed. Oh, okay. And now I'm bumping up against the next break again. And also, right. So that some of the provisions that were also being put in was you would need to carry the vote statewide by 60% in order to consider the amendment adopted rather than just, winning the election with a simple majority. Okay, so that sets all of that up. And now, of course, the music begins. So where shall we leave off? Well, right about where we left off when we discussed it yesterday, that this happened in the state Senate because the state Senate is 26-7 Republican. And now we have to wonder, okay, how will it go in the state House? And what will be the upshot of all of this? When we return from this short break, we can give you the answer to that, then add other pieces to the puzzle to get you ready for the weekend off. All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. So let's get to the brazen attack and the parts of the brazen attack that we didn't get to yesterday. After pointing out the overwhelming majority of Republicans in the state House here, the state Senate, run 26-7 by Republicans, has already passed its proposed 60% threshold amendment, which calls for an August 8th special election to consider it. The measure, Senate Joint Resolution 2, and a companion bill to reinstate an August election, just one though, Senate Bill 92, are pending in the Ohio House. So, by the way, this is just fantastic stuff. In terms of the use of the power of the gavel, right? You've outlawed the use of referenda in August elections. So what do you do if you want to sneak one by? You change the rules for one election. Can you do that? You shouldn't be able to. It's obviously a power grab and quite lopsided, but then so is the composition of the state Senate. So what the hell? Let's just go do it. We got the numbers. No one can stop us. The House is where the shell game possibilities are especially ripe, the editorial continues. The Ohio Constitution requires 3/5 of the members, respectively elected to the Senate and House, to place proposed constitutional amendments on the ballot. 20 out of 33 senators and 60 out of 99 representatives. In theory, Republicans hold 67 of the House's seats, but because of a GOP caucus split between House Speaker Jason Stevens and a faction loyal to Representative Derek Merrin, 2 GOP House seats remain vacant, leaving the 99-seat House with a net of 97 members. By some interpretations, that could let the House place the proposed amendment on the ballot with 59 votes instead of the previously assumed requirement of 60 votes. That may sound like trivia, but for two things. First, the House vote on the amendment is expected to be exceedingly close. And second, the GOP-run Supreme Court would likely have to decide the question, and if past is precedent, the court would let the House do whatever the House wants. Usually is the case with houses. It's nearly impossible to overstate how blatant these antics are. In effect, a majority of the state Senate, and likely, but not certainly, a majority of Ohio's House, aims to signal its contempt for the state's voters by trying to rig rejection at the polls of the abortion rights proposal, as well as a likely 2024 anti-gerrymandering plan. This is politics at its grubbiest. Were its operatives capable of being ashamed? They should be. That's the end. So now you know exactly how they feel about that one. But I thought that was really remarkable in terms of procedural engineering. One of the more, brazen displays that I've ever seen. And there are an awful lot of them. More every day. So now let's go back to Pocket and discuss some of the other things I have in store for you. One, referring back to some of the courtroom activity in the last couple of days, specifically the Proud Boys trial. An interesting and very good point here made by one Gwen Snyder on Mastodon, but who uses the screen name of Gwen Snyder is Uncivil. I'm not that familiar with Gwen Snyder, but I've definitely seen her name in her tweets before, and usually about the Proud Boys, and that's not surprising because she, I think, is a researcher and writer on the subject, and an anti-fascist researcher and writer in general, and who has focused on the Proud Boys, and who the Proud Boys have focused on in return, redoubling her efforts to focus on them. But she makes this very interesting point about her, I guess, in describing her feelings about yesterday's verdicts. She says, I'm feeling some feminist feelings regarding yesterday's verdict in the Proud Boys trial. Zach Reel, one of the Proud Boys convicted of sedition, headed up the chapter that terrorized me, my building, and my neighborhood as retaliation for my research. For years, people gaslit me about it. How so? Let's find out. The first time the Proud Boys paid me a house visit, some accused me of being a hysterical woman who made it all up. That doesn't surprise me that someone would accuse you of that. I mean, it's surprising, astonishing, and shocking. But on the internet, you'll find somebody, at least, who can always do that. Hopefully they can be ignored, but sometimes it happens in greater numbers than you would wish, and sometimes that makes it impossible to ignore. Others suggested I was some brunch-eating lib lady too blithely privileged to have known that this was a possibility. Both were false, both were sexist. I could absolutely see each of these things happening. The Proud Boys come and harass you at your home. There are definitely going to be some people who are like, oh, come on, they weren't targeting you, or you think you're so important, or even if they did do it, who cares? All they did was march around outside your house. What's your problem? And then the others who helpfully say, and this surprises you? They're fascists. Of course they're going to do this. Can't believe that it took until now for you to realize that they were going to do that. Yeah, thank you. That was so super helpful. She's being harassed. Maybe you could, say that's terrible, actually. And even though I would have anticipated that if I were you, I feel bad for you and we should do something about it. But no. Also, no help coming from the cops. Cops told me the repeated escalating threats were no big deal. Meanwhile, Reel's Proud Boy chapter taunted me. They held a recruitment event at a cop-owned bar around the corner. They called a rally at the park catty-cornered to my home. Whenever I named the harassment, keyboard, quote, leftists, almost always men, she notes parenthetically, came out of the digital woodwork to accuse me of centering myself. Oh, you're making it all about you. Well, I'm the one being harassed, but yeah. As if naming their intense, violent, and misogynistic behavior towards me somehow detracted from the project of opposing them. Probably the best example of this was the park rally, when those keyboard accusers mocked me for supposedly imagining the rally was targeting me. The Proud Boys themselves issued a clarifying statement explaining that, yeah, actually I was the intended target. The Proud Boys didn't show to the park that day. That's one of their problems. They just generally don't show up for things. But it's great. It's their problem, but it's fantastic for the rest of us. But they did show up in front of my home, conspicuously making laps over and over again with a visible firearm. When I took video of them on their umpteenth lap, they turned to the camera to say, "Hi, Gwen." In their national chat, Proud Boys speculated that my problem was, well, we'll clean this one up a little bit because of the nature of the program, was being undersexed, let's say. They did not use that word, not the sexed term for it. They used the F term for it instead. They challenged each other to take one for the team and rape me. That's fun chat, don't you think? They made Megan's Law flyers with my address and photo, falsely accusing me of being a convicted pedophile. And I guess they put them up around the neighborhood. How nice. Violent misogyny isn't incidental to the far-right ethos. It is central. And yet, at every turn, women who name the far-right's violent rage are accused of centering ourselves, of being unserious divas who are trying to pull focus to gain attention. When we name their misogyny, we are subjected to more misogyny. When we name the violence they unleash on us as women, because we are women, we are accused of being unserious and attention-thirsty, of selfishly trivializing the threat they pose. No, they hate women, most especially women that challenge them. They actively work to terrify us, to get us raped and or murdered. Anytime I leave my home, I know that there is a possibility that today is the day someone makes good on the threats. I carry this with me as a researcher and as a mother, a position that renders me socially and physically vulnerable. It's a lot harder to move away quickly from a guy in a suspicious hoodie when your toddler has decided her legs are suddenly spaghetti, right? You can't always convince the toddler of the seriousness of the situation. The day I tested positive for my pregnancy, we were contemplating going into hiding for the month. Post-January 6th threats from Nazis had reached such a fever pitch we didn't feel safe at home. There were angry knocks at the door downstairs. They'd photoshopped my head onto a meat hook. As much as I oppose the carceral state, there is something validating about seeing the Proud Boys facing actual consequences. At the same time, though, I'm angry. Now, here's where the point, this was a good point up to this point anyway, but there's an even better point, I think, made right after this. Ready for this one? This is a good observation. Their violence, the Proud Boys, and their threats against vulnerable people weren't ever treated as worthy of attention. It wasn't until they bruised some cops that anyone really seemed to care. In fact, those of us who were vulnerable and named their violence were punished. Punished not just by the Proud Boys, but by those who endlessly mocked and belittled us for naming the violent harassment we faced, for, quote, centering ourselves by naming that violence against us. So again, there's something, there's something meaningful in seeing that these people are finally, or that other people are finally taking their violence seriously. But it's also hard to miss which violence got taken seriously. The state didn't protect us. What it's done with these sedition charges is protect itself. And sadly, a lot of us were punished for asking the state and or our communities for protection when the Proud Boys came for us. At the end of the day, I'm mostly just tired. I'm glad this is over. I'm glad the state didn't give any appearance of exonerating these a-holes, but I'm also very aware that their most hateful behavior to vulnerable people was never addressed, that it was treated as unimportant and trivial. The misogynistic violence I faced, their racist violence towards non-white communities, their assault on trans folks, that wasn't what brought down the hammer. The state protected itself, no more and no less. It's what we should expect from the state, of course, but it's still exhausting. And that's the end of it. And I thought that was a very good point. And as much as we celebrate it, and as much as the state should protect itself, it's an interesting point, right? What actually motivated the state to bring down the hammer against these people wasn't what it was doing to individual citizens whom the state has the obligation to protect. They decided to forego that obligation. But threaten us or hurt cops, well, that'll bring the hammer down. And it should, but it should just be one of many things that can bring the hammer down. And so far, that hasn't been the case. Very interesting and a good point. Just wanted to make sure I got that in there. Now we can turn our attention elsewhere. Let's see. First of all, this I thought was kind of interesting. I guess I should introduce it by saying that I did read yesterday, and I knew this would be the case, that in seeking re-election, West Virginia Senator Joe Manchin, apparently considered among the most vulnerable members, and that current polling makes it look as though it's virtually impossible for him to be returned to the Senate now that incumbent Republican Governor Jim Justice has thrown his hat into the ring for that Senate seat, that he's widely popular enough in West Virginia that he should, the polling currently, and it's still early and it's always just a snapshot, says he should be able to oust Manchin. Which of course made me stop and think about all the things that Manchin had done as a Democrat that felt very Republican, and that were all of course aimed at confounding Democrats and therefore, I guess, confusing Republican or Republican-leaning West Virginian voters into returning him to the Senate, even though he's a Democrat, which, as frustrating as Manchin can be, is still something considerably better than filling the seat with an actual Republican, even a Republican who previously claimed to be a Democrat. And even then, that's not much, because apparently prior to that, he claimed to be a Republican. He switched from Republican to Democrat to run for governor the first time, and then switched back to run the second time. So he was never really a Democrat to begin with. But anyway, it just makes you stop and think and say, you know, all that stuff, all screwing over the Democrats so many times in an effort to squeak by in one more election, and then to instead actually be crushed and not return to the seat, makes it feel like all those sacrifices were for nothing. And I don't anticipate at any point Manchin saying, well, I'm screwed regardless, so I might as well vote like a Democrat for the rest of my time in office. And I have a feeling instead he'll say, maybe I can still fool some people by pretending to be a Republican. Anyway, maybe, I don't know, maybe this complicates his decision because, what do you know, Governor Jim Justice is in the news, and guess who's reporting the news? It's ProPublica. What do they have to say? West Virginia Governor Jim Justice runs for Senate amid stacks of unpaid bills. Does it matter? Let's find out. Subheader says, as Big Jim, as I guess he calls himself, hopes to take on Senator Joe Manchin, Justice's family businesses face allegations of unpaid debts, overdue environmental fines, and conflicts of interest. Oh no. I can't believe it. And he's a Republican too. So you know that will. All right. Well, anyway, Ken Ward Jr. is gets the byline for this one. Mountain State Spotlight. Is that his usual publication? I guess so. And so working in partnership with ProPublica, he tells us this. For years, West Virginia Governor Jim Justice has been dogged by allegations that his family businesses haven't paid their debts. He's just pulling himself up by his bootstraps, you know, playing by the rules and all that, including fines for environmental violations at their coal plants. Perfect. One bank is even seeking to garnish his salary as governor. Wow, to cover an unpaid personal guarantee of a business loan, court documents show. But these disputes are likely to resurface in what will be one of the most hotly contested races for control of the U.S. Senate in 2024. Last week, Justice, not our justice, but theirs, a Republican who is immensely popular in the state for being such a jerk, I guess, announced that he will challenge Senator Joe Manchin, a Democrat who is often the swing vote on key legislation. A review by ProPublica in 2020 found that over 3 decades, Justice's constellation of mining, farming, and hospitality companies, he just owns everything, I guess, were involved in over 600 lawsuits, wow, in more than 24 states. Many were filed by workers, vendors, business partners, and government agencies, alleging they weren't paid. How Trumpian of him. Often, similar cases were filed in multiple jurisdictions as lawyers for plaintiffs tried to chase down a justice company's assets to settle debts. By late 2020, the total in judgments and settlements for justice family businesses had reached $140 million, ProPublica and Mountain State Spotlight found. Since then, his family business empire has faced more turmoil. Lenders are trying to hold him personally responsible for hundreds of millions in debt. Courts are ordering payment of long-standing environmental penalties. Neither representatives for justice nor the family's business has responded to requests for comment. In the past, Justice has said, everything shifted now all of a sudden, said that he and his family's companies always pay what they owe. That sounds like it's a lie, actually, don't you think? The governor has said that his businesses don't create any conflicts of interest and that he didn't run for office to get anything for himself. Justice inherited a coal fortune from his father and expanded it into an empire of agricultural companies and resort hotels, including the Greenbrier, a posh historic resort located in a valley where southern West Virginia's mountains meet western Virginia's rolling hills. Last week, Justice used the Greenbrier as the backdrop for his announcement that he would seek the Republican nomination, facing U.S. Representative Alex Mooney in the GOP primary. Manchin has not announced a re-election bid yet, but in response to questions about Justice, he said, "Make no mistakes, I will win any race I enter." Okay, sure. As we documented, the resort has been at the heart of various conflicts of interest as major trade associations that lobby state government for their industries have held meetings and conferences there. Hey, that sounds pretty Trumpian too, don't you think? And just 2 days before Justice's Senate announcement, another of his resorts, Glade Springs, which sounds like an air freshener more than anything else, was the subject of state Supreme Court arguments. Wow. In a case in which the Resort Homeowners Association is seeking $6.6 million in property upkeep fees from one of Justice's companies, which owns lots at the resort. When he became governor in 2017, Justice said he was turning control of his family businesses over to his adult children. But our investigations found that while governor, he continued to steer the empire. Wow, that sounds Trumpian too. In his political campaigns, Justice frequently touted his experience as a businessman. Wow, that sounds Trumpian too. And said that his long career in coal and other industries made him suited for the role of West Virginia's chief executive. Justice's coal operations have also been repeatedly pressed to settle allegations of significant pollution problems in deals with regulators. Yet the environmental violations have continued. Last month, a federal appeals court ruled that Justice companies must pay $2.5 million in environmental fines. The lawyers for the companies had argued that the fines were the result of a misreading of an earlier settlement. In December, an industrial plant owned by Justice's family agreed to pay nearly $1 million in fines after releasing excessive air pollution into black neighborhoods in Birmingham, Alabama. An attorney who works with the Justice family said the consent order would, quote, provide the certainty that the company needs to complete its evaluation of the plant's future. Whatever that's supposed to mean. For years, Justice had been considered West Virginia's richest man and listed by Forbes as a billionaire. Wow, that sounds Trumpian too. But in 2021, Forbes removed that listing. Wow, that sounds Trumpian too. The magazine cited a dispute over $850 million in debt to the now defunct firm Greensill Capital. The Justice companies settled that dispute with a payment plan, but last week a longtime banking partner of Justice's, Carter Bank and Trust, filed documents seeking to collect on a separate $300 million debt. Justice's son, Jay Justice, said in a statement that the bank had refused a reasonable payment plan. Well, that sounds pretty Trumpian as well. So anyway, there you go. That's on background, and we'll see whether that becomes an issue in any hotly contested elections to come, or whether it solidifies his position as leader of the Republican Party at some point. Okay, let's go back and, oh, wait a second. I've put aside a tweet that needs identifying. Ah, yes, okay. Well, a couple of things I could play for you. Well, this is pretty interesting. Maybe we can do this on our way out. Darwin has sent us this interesting snippet here. Have I? Yeah, I guess I do have it in Pocket, and so I'll have to open it on the big computer in order to get to it. But why? It's all the way down here. Is this right? Is this the right one here? Or I feel like it was further down when I was scrolling before, but maybe not. Okay. Well, anyway, he says about this one, Darwin says, you, meaning the person in the, really, I guess the person in the, making the speech, as opposed to, well, is it the same person who's tweeting it around? I guess so. Maybe so. James Tallarico, who is a Texas state representative and a former middle school teacher, according to his Twitter bio, is tweeting this around. Is this him speaking? Maybe. Yeah, I guess so. It's his own video. So he's the guy who wins the internet today, according to, or yesterday anyway, according to Darwin, who says of his speech, the entire thing is masterful and should be repeated word for word every time one of these stupid proposals creep up across the country. And I guess you'll figure out what kind of proposal it is once I play you the video, provided that this is the actual tweet. Come on. Let's wake up and bring it up here, Pocket. Is this the right one? Playing the Jeopardy music in my head. Yes, here it is. Okay, so James Tallarico speaking, I guess, to fellow members of the Texas state legislature here. And is the audio all the way up? Yes, okay. And you'll figure out as you go on what the proposal is. And by the way, you'll also be able, it's not discussed here what the outcome of the vote was, but you'll probably be able to guess.
I say this to you as a fellow Christian. Representative Noble, I know you're a devout Christian, and so am I.
Here he goes.
This bill, to me, is not only unconstitutional, it's not only un-American, I think it is also deeply un-Christian.
Oh.
And I say that because I believe this bill is idolatrous.
My.
I believe it is exclusionary, and I believe it is arrogant. And those three things, in my reading of the gospel, are diametrically opposed to the teachings of Jesus. You probably know Matthew 6.
Before I continue to play it on here, I mean, he does describe exactly what's going on here. What's the bill that they're talking about? The bill, very helpfully, is to require that the 10 Commandments be displayed in every classroom, I guess, in every public school classroom in Texas, or something to that effect, as I recall. But it was all about the display of the 10 Commandments, because that'll change everything somehow. But again, let's go back just a few seconds so that he can explain his view on this thing. What's wrong with displaying the 10 Commandments? This is actually quite interesting. All right, so we'll replay this and then go through the rest of it.
Also deeply un-Christian.
Un-Christian.
And I say
this.
that
Why so?
Because I believe this bill is idolatrous. I believe it is exclusionary. And I believe it is arrogant. And those three things, in my reading of the gospel, are diametrically opposed to the teachings of Jesus. You probably know Matthew 6:5, when Jesus says, don't be like the hypocrites who love to pray publicly on street corners. When you pray, go into your room and shut the door and pray to your Father who is in secret. A religion that has to force people to put up a poster to prove its legitimacy is a dead religion. And it's not one that I want to be a part of. It's not one that I think I am a part of. You know that in Scripture it says faith without works is what?
Dead.
Is dead. My concern is, instead of bringing a bill that will feed the hungry, clothe the naked, heal the sick. We're instead mandating that people put up a poster. And we both follow a teacher, a rabbi, who said, don't let the law get in the way of loving your neighbor. Loving your neighbor is the most important law. It is the summation of all the law and all the prophets. I would submit to you that our neighbor also includes the Hindu student who sits in a classroom, the Buddhist student who sits in a classroom, and an atheist student who sits in a classroom. And my question to you is, does this bill truly love those students?
I'm going to go a different direction than I think you're trying to lead me.
She feels that she's being led in all of this discussion. Okay, we're a little bit late with our music going in, but I realized only just seconds too late that I could have overlapped what he was saying with what was going on. But all right, so how did you like that? That was some kind of a speech, too. The exclusionary stuff I'm sure we could have predicted, but interesting. Idolatrous, and why not feed the hungry?
Hi, I'm Scott Anderson, the guy that writes the daily summary for this show, Kagro in the Morning. Thank you to everyone that supports this show. Many of you send donations through PayPal, Patreon, Square Cash, Radio Public, and so on. Some of you write your own essays and send them in, or read articles with your own commentary. We appreciate it. Now, some of you are listening to this and thinking, I'd like to help, but isn't there something I could do that wouldn't require money or effort? Why, yes, there is. You can just like us. On Daily Kos, they call it the recommend button. YouTube has a thumbs up. There are hearts and likes and love buttons. Tap our love button. Tap our love button every day. Share our shows and summaries on Facebook and Twitter, YouTube and iTunes, Stitcher and Amazon. Most of these places allow you to write a review, so a sentence or two would be great. Recommend us to social media, or tell your friends to listen to the show. You aren't just helping us, you're helping them find their new favorite thing to listen to. You could change the world. So thank you in advance from me and everybody else in the world.
All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. A little bit late because our music started late, and hey, it confused me, and I'm looking over the 15 to 20 different things that I wanted to get on the record by the weekend. Really, it could be by any weekend. And though that does remind me that, actually, I've got a couple of housekeeping items to bring up. One is that there will be no, I mentioned this in one of the daily posts the other day, but you know how that goes. Housekeeping item, I will not be on the air for live shows Thursday or Friday of next week. You will hear me constantly fretting about the high schooler trying to make it on time to the bus. Of course, his graduation is coming up, but that's not what occupies my time Thursday and Friday. It is the much less frequently mentioned in recent years college boy who occupies our attentions as he graduates from college, and that happens next week. And wow, that's time flying for you. I got 2 graduations to deal with in May. One of them, though, being high school, is local, because I don't send my children to faraway boarding schools, except for college, which I guess counts as a faraway boarding school. But graduation coming up, and I've got to be on hand for that on Thursday and Friday, so no live shows, sorry to announce. But the fact that I've got so much waiting in the wings to be discussed bodes well for the opportunity, anyway, to fill the time slots with special pre-recorded shows. Whether or not I'll find the time to actually pre-record them is another question. And one other housekeeping item that's been waiting for just a little while here. The thanking of newest sponsor via Patreon, who, though real name appears to have been provided as well, has nonetheless, we're into the identity thing these days, right? This is how you've chosen to be identified, by the handle. It's your idea, not mine. Hipster Bitch. Okay, well, you know, thanks, Hipster Bitch. We appreciate it. A new sponsor via Patreon as of April 26th. And I guess we're making a habit of calling people out as they join a little quicker anyway, even though it's been a little while. Sorry for the delay, hipster bitch, but I was being hip to so many other things at the time. All right. So among the things that I wanted to make you hip to these days, there's a lot. Well, there's more Tucker Carlson stuff. And I definitely actually do want to get to some of that. We won't today, probably. But just because I think it's hilarious that every day I say, that's enough Tucker Carlson stuff. What do we really need to talk about Tucker Carlson for anymore? And then I give in to more speculation about why he was fired. And he was fired because he's a jerk ass. And the fact that the people who fired him are also jerk asses really doesn't enter into the equation as far as I'm concerned. But there is more news. But I'm going to go in a different direction. Let's see. There's definitely a couple of things here that are weird and out there and you haven't heard about. But first, something that's weird and not that out there that you have heard about that I think needs reinforcement, but luckily I don't have to actually reinforce it because Alex Wagner is the one reinforcing it, and the clip or the clip that I've got for it is a video clip from her show and not a readable piece. So I refer you to, and I'll link you to Alex Wagner's discussion of this important precept, which we've laid a groundwork out for over the past couple of days. It was just nice to see it confirmed. Nothing better than confirming your priors. Trump and allies, this is the headline here, Trump and allies work to water down the meaning of insurrection to excuse the January 6th riot. This is just a compilation of the stories of the expulsion of the lawmakers in Tennessee, in the threats against the lawmaker where's Zoe Zephyr from? Montana? Yeah. And then a couple of other legislators also in various state legislatures dominated by Republicans, likewise being accused of insurrection when they voice protest over things. Any kind of protest, when a Democrat apparently does it, will now be labeled insurrection. Even though we've had now 2 seditious conspiracy trials end in convictions, precisely because there's so much more to it than First Amendment protected protest speech. It's just kind of a remarkable thing to keep an eye on, and it's important to do so. So I'll refer you to and give you a link to Alex Wagner's recounting of this phenomenon over the 3 minutes of her clip. Okay, and I still have Rosalind McGregor's update from Michigan to bring you. But before I do that, let me at least get one of the weird esoteric things on the record. And I guess somewhat in keeping with this weird interpretations and misinterpretations of the law in order to label people either insurrectionists or otherwise punishable troublemakers. This is an interesting entry in Jezebel magazine, Jezebel.com. Kylie Chung filed this story on Tuesday, the date of which I forget, but just helpfully says Tuesday in the byline. Texas prison guards put woman in isolation for talking about abortion. What's happening here? This is a weird one. Basic abuse of power by prison guards, but also maybe basic understanding of everything that they were exercising power to control, because you won't believe it. I'm going to skip the subheader because it gives away too much and give you quickly the rundown of the write-up. An incarcerated woman in a Texas prison is being kept in isolation and punished for talking to other women about abortion, The Nation magazine reported on Tuesday. But I'm going to read Jezebel's version of it because that's what's here. The punishment was doled out mid-April, shortly after the woman, Quanetta Harris. I'm hoping that I'm pronouncing that correctly. Kwaneta. Quanetta Harris began sharing information about sexual health and preventing pregnancy with other inmates. Sounds like a good thing, right? But you know how it is in Texas, whatever. Harris told The Nation the ordeal began when she heard several younger women talking about contraceptive methods in a way that was riddled with scientific inaccuracies. Bad, right? As a nurse prior to her incarceration, she began speaking to the women to offer clarification, hoping to protect the women from unwanted pregnancies and sexually transmitted infections. Now, at some point, the topic of abortion arose when one young woman asked Harris about, quote, partial birth abortion. You all know about that. An inaccurate and stigmatizing term that anti-abortion activists use to refer to an abortion later in pregnancy. Harris said she gave them the facts without realizing a prison guard was in earshot. Although you should always think, well, prison guards are probably always in earshot, but this isn't the sort of thing that you would think they would give a crap about. So what the hell? I mean, if you're planning an escape, don't speak in earshot of prison guards. But if you're talking about abortion, why should he care, right? Especially if you're actually giving accurate facts. But giving accurate facts, you should probably realize, well, I'm in Texas. We're talking about a prison guard in Texas. Giving accurate facts about abortion might be something that offends these people. They don't have the right to be offended, but they don't need rights. They're prison guards. They just take it out on you because they feel like it, and no one will ever really hear the story. Well, anyway, so again, the topic here, suddenly they bring up, what is this partial birth abortion thing? Well, she says there's no such thing. Harris told the women most abortions are medication abortions and dispelled with anti-abortion myths. At that point, a guard, whose name Harris didn't catch, but whom she identified as a young man in his 20s, intervened, annoyingly enough, berating the women, annoyingly enough, and yelling at Harris, ready for this one, to shut up, and threatening not only a disciplinary ticket for violating prison rules somehow, but even a new criminal charge somehow, which could lead to additional prison time, the Nation reports. Now, on what basis, and why would he even bother? There's more. Shortly after the incident at midnight, Harris says a prison lieutenant came to her cell and she was taken to a different, isolated cell at the far side of her unit, closed off from the others and facing away from the prison yard. For 3 days, she was cut off from making any phone calls. She's currently unable to send or receive e-messages on her prison-issued tablet. I didn't even know they had those. Forced to rely on prison staff to give her printed-out messages that are days old and in tiny print. Harris, a mother, told the Nation she fears at any time the prison will cut her off from communications with her kids. Now, to be clear, what Harris did is not illegal in any state. Not what she did to get herself in jail. That apparently is illegal in Texas. But speaking about abortion at all, even incorrectly, is not in violation of any laws anyway. While some states like Texas and South Carolina have floated bills to criminalize aiding and abetting abortion and prohibit internet providers from hosting websites with information about self-managed abortion, no laws currently criminalize talking about it. Nonetheless, there's an overarching culture of confusion surrounding abortion rights post-Roe, which has been exploited by anti-abortion activists and now apparently prisons to punish people and violate their rights. Local police departments have long exploited confusion and misinformation that equates self-managed abortion with feticide to criminalize pregnant people and those who help them. Access to sexual health resources like abortion and even information about those resources has always been mired in barriers in prisons, where some states even continue to permit prisons to shackle pregnant incarcerated people. Even before Roe fell, one study showed about 70% of incarcerated people didn't realize they had still the right to an abortion. Despite having this right, most prisons make it impossible to access. A study showed that 2/3 of prisons that allow abortions require the pregnant person to pay for all associated costs, an impossible feat considering some prisons pay incarcerated people just 8 cents per hour for their labor, even if they do work. Harris told the Nation that she believes the prison is using her to send a message to other incarcerated people to, quote, shut the hell up. That sounds about right to me. Now, what I am missing in all of this is there's no, I thought this was in the body of the report, but it's not, but it's still up there in the subheader the most interesting part is, so why does this prison guard care so much? Well, yeah, it's not in here anymore. And I wonder whether they edited this out. How odd. Because that was part of what made this whole thing really interesting. I wonder whether the Nation still has this up in here or not. Anyway, what was alleged originally in the article and apparently is more difficult to find now, and let me see if I can go to the pocket version of what the Nation has got. This guard was apparently personally offended by this discussion because he insisted in the middle of yelling at her that he himself was, as he said, the product of a partial birth abortion, which leads you to question, do you even know what you're talking about? I mean, one, there's not even anything that has, that really is a partial birth abortion. And then, of course, if you're the product of an abortion of any kind, you're probably not there as a prison guard at that point. It just doesn't make any particular sense. But there you have it. So, here's, in response, the younger woman cursed him out, even, all right. Oh, this makes sense as to how this got screwed up. I guess they've made some corrections, and there's no indication of the correction. But I guess, because it didn't make any sense. The initial report was the officer saying, well, I was a partial birth abortion, so how dare you? And no. What actually happened, it seems now, in the, I guess, corrected text in the Nation, said the guard comes in and yells at her to shut up and threatening the disciplinary ticket and maybe even new criminal charges, which could lead to additional time. In response, the younger women who were there cursed him out, even telling the officer that he was a partial birth abortion. They were just insulting him. Again, that makes a lot more sense than running around saying, oh yeah, well, I'm a partial birth abortion. Yeah, so what? I mean, not only is that stupid, but what difference would that make to any of us, even if it were true, which it can't possibly be? All right. Well, anyway, that's an interesting twist on the clamping down on, well, all sorts of things, even sharing abortion information, just talking about it with somebody in an environment where you can abuse your power, obviously, is always a problem, but happening in prisons. Okay, interesting, but not quite the revelation that I guess I once thought it was. I wish I had spent that time on something else now, but why don't I regroup and let's pull up what we've got from Rosalind McGregor, and we'll reset because I'm pretty sure she probably has the story correct that she's reporting. Okay, thanks a lot, Jezebel. I wish I had checked in on that one a little sooner. Okay, Rosalind, what's happening in Michigan?
Good morning, David.
Good morning,
Today I'd like
Rosalind.
to bring to
Thank
your
you.
listeners' attention an article about the last public school system in Michigan to end using Redskins as their mascot name. The good news is that the Camden Frontier School District recently voted to retire the mascot and come up with a new one. It was the last district in Michigan to use Redskins as its school mascot. Superintendent Chris Adams announced the decision, quote, "The Board of Education voted on the motion to respectfully retire the Redskin mascot effective immediately with phased-out completion by the end of June 2024, Adams said. The school district plans to gather input from students, staff, administration, and community members for the next mascot. Native American groups have advocated for several years that the term is an offensive term in the indigenous community. Quote, "It has been an unavoidable topic for years for our school district as well as many other districts and organizations," Adams stated. In West Michigan alone, several school groups have worked with the Native American Heritage Fund to retire their indigenous mascots and rebrand. The NAHF launched in 2016 as part of an amendment to a 1988 gaming deal between the Nottawa Sepi Huron Band of the Potawatomi and the state of Michigan. Since its launch in 2016, the fund has distributed more than $1.5 million in grants to help Michigan schools in their rebranding efforts, like replacing basketball courts, murals, and signage. Belding was one of the first schools to work with the NAHF. Paw Paw, Sagatuck, Chippewa Hills, Saranac, and Hartford have also made the change using NAHF funds. The NAHF also contributed nearly $100,000 to Godfrey Lee Public Schools to help the district rebrand from the Rebels mascot that is considered offensive by many people because of its connection to the Confederacy and slavery. Superintendent Adams says this decision is not meant to overshadow or erase the school's history, but to move forward. Quote, "The passion, memory, and sentiments of alumni is not to be forgotten, nor will artifacts be thrown away. We will be preserving the history of the Camden Frontier School District. The retirement of the mascot is about looking to the future, not erasing the past," he said. Many schools and universities still use indigenous names or imagery, but most with local partnerships are meant to educate and help teach the history of indigenous tribes. Central Michigan University, which goes by the Chippewa, entered an agreement with the Saginaw Chippewa tribe in 2003. The university regularly holds cultural events dedicated to Chippewa history and culture and has developed educational initiatives to preserve that history and culture. In describing the partnership, CMU says the university uses the nickname, quote, "as a sign of honor, pride, and respect for the tribe's rich heritage," unquote. That's my segment for today. Just a little good news from Michigan. Back to you, David.
Thank you, Rosalind. Always good to have good news for a change from Michigan. There is good news, and I'm glad you took the time to report it. Always an interesting topic, that one, too. Things are changing, and that is good news. All right. So in the last couple minutes of the show for today, we're going to make our executive decision about which direction to go. And because I had referred to Barry Seed earlier and said that he came up in the story about George Mason University Law School's adventures in financing, let's say, let's return back to that, even though I'm not certain we can get all the way through to the end of the article again, but I just want to fill in the gaps. And that'll just be a lot harder to pick up again next Thursday or Friday than it would be to do now in closer proximity to our earlier reading. We left off, though, in our first attempt at reading through this New York Times article at about the point where the previous dean of the law school, Dean Butler, was trying to work a couple of financial deals to help bolster the standing of the school. But then they found that they were slipping in the rankings nonetheless, and he wants to turn things around. Mr. Butler, who retired as dean in 2020, I believe we did get this in just before the break, or the end of the show last time we discussed this, referred questions for this article to Scalia Law. I don't work there anymore. Ask them. But the school said it couldn't answer them since they related to Mr. Butler's tenure. But I mean, he was the dean of that law school. Of course, they could answer them. The law school, I mean, so could he. Just no one wants to answer questions. The law school, as they pointed out, established at George Mason in only the late 1970s, had carved out this distinctive place on the right flank of legal academia, the Law and Economics Center, devoted to one of the pillars of conservative legal thought, which again, they explain, the idea that courts must consider the economic impact of the law, had offered training to more than 5,000 federal and state judges. Among the school's most prominent alumni, and indeed its only Supreme Court clerk, was William Consovoy, right? Who helped persuade the High Court to strike down key provisions of the Voting Rights Act, which we were just discussing a minute ago with Ginni Thomas and her activities. For all that, and oh, by the way, who was Consovoy clerking for? Thomas. For all that, a year after Mr. Butler took over as dean in 2015, the law school's U.S. News ranking dropped to 45th. That, he said, or administrators of various stripes wrote that falling out of the top 50 would be a disaster from which the law school would have a very difficult time recovering. And also, by the way, in addition to just losing out on ranking, that's bad enough. But how do you justify getting Supreme Court clerkships for people who are graduating from a law school that isn't even ranked in the top 50? It would be blatantly obvious what they were doing if Thomas continued to employ them. So, by then, Mr. Butler had turned to Leonard Leo for help. What do you know? He was, of course, a rising power in the conservative ecosphere, helping to steer money to advance the Federalist Society's mission of filling the courts with judges who would interpret the Constitution according to the founders' intentions, which is all a lie. But doesn't get called out here. In September of 2015, the dean sent Mr. Leo a 5-year plan rooted in their shared belief that opportunity and a deep well of donor money lay in doubling down on the law school's efforts to become an alternative to the left-leaning institutions that ruled the rankings. Sorry. Reality has a liberal bias. Scalia law, Mr. Leo wrote in response to questions from the Times, is a model for what legal education should be in our country, grounded in objective analysis, blah, 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 blah. The windfall and the way forward came quickly. About 2 weeks after Justice Scalia's death on a Texas hunting trip in February of 2016, paid for by some anonymous billionaire, and he's vacationing at his home again, and I wonder who that is, and we may even know that already. But gosh, this happens a lot. After that, Butler and Leo struck a $30 million deal with donors to rename the school for Scalia. $10 million came from the Charles Koch Foundation. We read that whole list of the funders of the Mercatus Center when I brought that point up earlier this week. Charles Koch Foundation tops on the list for them. $10 million from Koch. The school explained also the balance of it came from an anonymous donor who had approached Mr. Leo. Parenthetically, it says here, the benefactor is widely believed to be Barry Seed, an electronics manufacturing mogul and conservative donor who would later make an extraordinary $1.6 billion contribution to a political group controlled by Mr. Leo. It's weird how the checks pass around in such a small, tight circle. The announcement rewound an earlier controversy set off by revelations that gifts to George Mason from the Koch Foundation had come with influence over hiring decisions. The foundation, in a statement, said it was deeply committed to, quote, fostering an open exchange of ideas among a diversity of perspectives. Diversity? You're rhinos. Get out of here. The double deal was a masterstroke. The money would, among other things, allow the law school to support new research centers organized around areas of special concern for the legal right, including a Center for the Study of the Administrative State, thanks Steve Bannon, and a Liberty and Law Center. Wow, there's that Liberty Center thing again, and golly gee, if that isn't what, what's her name, Ginni Thomas called her organization, too. The renaming would be a bridge to the court. At the morning dedication ceremony on October 6th, Justice Kagan, the cover story here, spoke on behalf of the court. In addition to the Union Station dinner mentioned the other day when we read about it, Mr. Leo hosted a private luncheon for justices and other VIPs, offering vegetarian or lobster risotto. How do you like that? Lobster is great, future Justice Kavanaugh wrote, emailing his menu choice. In all, the school collected at least $750,000 that day, records show. 7 justices, all but Chief Justice John Roberts, attended some portion of the festivities. That's access for you. That it could not be 8 came courtesy of the Senate Republican leader Mitch McConnell, who had refused to consider President Barack Obama's choice to replace Justice Scalia before the upcoming presidential election. When Mr. Trump won, he inherited the opportunity to fill the open seat with a conservative drawn from a list of candidates developed by Mr. Leo. It was a chance for Scalia Law School now to fast-track its ambitions. Next section, quickly enough. Wooing the justices. We'll see how much we can get in a minute. As Justice Gorsuch moved to the top of the list for the court seat, he convened a war room of confidants to lobby for his nomination and help frame a confirmation strategy. Among them was Jamil N. Jaffer, a Scalia law professor and founder of its new National Security Institute. Mr. Jaffer had clerked for the judge on the appeals court and counted him as a friend and mentor. After the Supreme Court confirmation, Mr. Jaffer acted as the Gorsuch's unofficial relocation consultant, meeting with a real estate agent and touring at least one equestrian estate in Virginia. Thanks, Jaffer. Smiley emoji, the justice's wife, Louise Gorsuch, wrote after he sent an aerial photo of the property. The justice followed up by asking Mr. Jaffer to arrange a tour for his wife, which is just what most law professors do, right? Mr. Jaffer agreed to take time off from Scalia law to join the new justice's chambers as his temporary clerk. He also began recruiting Justice Gorsuch to co-teach a law school class the following summer in Italy. In response to questions from the Times, Mr. Jaffer said it was a terrific opportunity for students to learn from Justice Gorsuch, whom he described as an esteemed scholar in his own right. He said he had been glad to volunteer his personal time to help the justice search for a home, as I would for any friend. That is becoming a recurring theme with these people. On the faculty, Justice Gorsuch would join Justice Thomas, who had recently completed his first semester teaching alongside Naomi Rao, a former Thomas clerk, who would become a Trump administration official and federal judge. That September, Mr. Jaffer sought Justice Gorsuch's feedback on the draft memo for the Italy program, which he laid out why he would be such a prize catch for Scalia law. Justice Gorsuch is, of course, the newest member of the Supreme Court and the youngest to be appointed to the High Court in a generation. He also holds the seat of the law school's namesake, Antonin Scalia, and is widely believed to be a worthy successor to the legacy of that great man. The proposal included descriptions of potential sites, relying in part on advice from Mr. Leo, who could use his, quote, significant connections in Rome and at the Vatican, should they be required. Now, other law schools have hosted justices on expense-paid trips abroad. NYU, for example, sent Justices Ginsburg and Sotomayor to a conference in Portugal in 2019, though they did not receive teaching salaries. Big difference. In 2016, Tulane paid Justice Alito to teach in Berlin and Paris, according to his disclosure from that year, and covered his expenses. Notre Dame, which counts Justice Amy Coney Barrett as a longtime faculty member, has recently been vying for the court's attention too, sending Justice Alito to Rome and Kavanaugh to London. But, you know, this program is a little bit different. Created entirely for the justices in locations of their choice.
You have been listening to Kagro.
And coming with a $3,000 salary. And expensive apartments and transportation and food and transportation for their friends and family who get invited to speak on panels, including, unfortunately enough, Justice Kagan, who went to Iceland as the cover story, all paid for by the organization. Seems very different. Perhaps we'll have a chance to talk about that and more next week. Stay tuned.